Good morning, Mr. Boland.
Good morning, Your Honor. Your Honors, may it please the Court, my name is James Boland. I'm here for the respondent, Mr. Hilson, who is present, and my colleague, Sarah Holden, is here as well. We ask you today, Your Honors, to take a courageous step and undo the action wrongfully taken to discipline this lawyer. There are a few cases in the bar discipline panoply that call for reversal, and this is one of them. There was no escrow in this case. There was no entrustment in this case. There was no false testimony, and there was no violation of Canon 4. This case cannot be sustained on the facts or the law. We're here today because this lawyer was holding his own client's money in his client's funds account.
Wait, how can you say it was his own client's money? Wasn't there a judgment that, from the Superior Court, that half the money was due to the sellers?
As Your Honor knows, there's a substantial body of law that in which the sellers, the Garganos, held a judgment. Now, that does not convert the money, which was Ms. Holmes, the broker's own money. Remember, going back a step.
But at one point, your client sent, at one or 2 points, your client sent a check.
He did indeed.
He must have thought at some point that it was the other.
No, and absolutely not. I do respectfully disagree.
Why did he send it to?
Because she directed him to pay the money. It's her money. Go back a step and recall that she was holding this money as a broker in a failed real estate deal. She then stole the money. She then replaced it, delivered it to the respondent, put it in his own client's fund account. Client's fund account. Now, she directs him by a written authorization to deliver the money to the other side after judgment. They wanted the entire deposit. They got an order for half of the deposit. He delivers the check. They reject it. They don't want to take it pending appeal. They filed 4 motions with the lower court seeking to protect in some fashion these funds so that they be held for them. Every one of those motions was rejected. Every one.
But weren't they all rejected precisely because the judge trusted your client to continue to hold them?
Don't think so, Your Honor. I don't think there's any evidence to that specifically. I think that's a supposition. I think that puts a burden on a lawyer, in this case when he's holding his own client's money. I think at the end of the day, when we parse down through this becomes a case where there is, frankly, I think there's no basis for the finding of this, but this becomes a case where there is such a misunderstanding or misconstruction of what was supposed to transpire that you have 2 parties going completely opposite directions. One party, the sellers, believed that they were entitled to the money, that they had an expectation. The respondent, who wrote letter after letter rejecting the requests, for example, that he hold the money in escrow or in trust. Let me point to you, if I may, specifically 5 facts that the hearing officer and the board ignored. And if you find these facts, which are undisputed, and I believe you must find them in your review, then you cannot come to the conclusion that existed in this case. First is Exhibit 23. It's a letter of November 2nd, 1995. Hearing officer completely ignored the critical language in that letter. She referred to it otherwise. But the Garganos, the sellers, requested that the respondent hold the money for them pending the appeal. The respondent wrote, "While I acknowledge that you, quote, requested that I hold the monies in escrow pending your client's appeal, I submit that I had no obligation to do so." After learning that the funds had been dispersed, the Garganos then went and filed another motion seeking to compel the return of funds, which the court denied. And I submit to you that that denial of the motion, in those circumstances, ratifies his belief, his position that he was not obligated to hold the money for the third party. There is no court order requiring to hold money in trust. There is no escrow agreement. And there's also the following testimony that was flatly ignored. The seller's counsel testified at the BBO hearing years later that there was no restriction on the funds that Mr. Hilson was holding of which he was aware.
Could I ask you, when the various motions were filed seeking to have it put in escrow or whatever, what did, and I take it that Mr. Hilson, on behalf of his client, opposed those motions?
He did.
What were the grounds of his opposition?
That these were his own client's funds, that he was holding them at the direction of his client, that he did not agree to an escrow, he did not agree to hold them in trust. There was no order thus far that he held them in trust. There was no order that he hold them in any other way. There was no escrow agreement between the parties. The seller's attorney testified at the BBO hearing that there was no written escrow agreement.
Right, but when one of the grounds I gather that the judge didn't order it was simply to say, no, we're going to try this matter very quickly and have it done with. Surely that suggests that what the judge is relying on is the pragmatics, the belief that the lawyer will in fact hold them, and it is not necessary to set up a more formal, costly, cumbersome arrangement for the brief period of time before the case will be tried. And indeed, the case is tried quite promptly. That seems to suggest that the judge was relying on the idea these funds aren't going to disappear in a month or two.
Well, if Your Honor, please, obviously, His Honor did not testify as a witness in this case. We don't have that precisely in the record. And I think that's supposition to presume as to whether or not that was the understanding, because there's nothing in the order. It's simply denied. And what you have then is that is not relied upon by the hearing officer in the finding of this case. What you have is, again, let me give one predicate fact. Bar counsel files a petition in this case in which the proposition is that the respondent is either an escrow agent, in which case he's a fiduciary for both parties, or a trustee for a third party. Now, those positions are utterly inconsistent as a matter of law.
Why isn't it a constructive trust?
Well, it's not a constructive trust because this is not funds for the third party. It's merely the client's funds. They're not earmarked for a third party.
But they're disputed funds.
They may be disputed funds, but they're the client's own money. And
But
they're disputed.
They're not the client's own money.
There's already a judgment saying they're not the client's own money.
Well, the client provides the money to the attorney. He's holding in his client's fund account. We have the other side saying
Then there's a judgment. There's a judgment saying it isn't your client's money, it's 50% the seller's money.
No, in fact, that's not what the judgment says. The judgment is, in every civil case, simply says, I award you a judgment, go collect it.
All right.
And the case law in this Commonwealth is very clear that a judgment creditor merely has an unsecured right to seek to collect on the judgment. That's all they have. If you hold this decision in this instance, in the way in which it has been determined, you are making a lawyer holding his own client's money the guarantor of payment for a judgment creditor who has taken steps to secure the money and failed on the underlying action, who has taken no action to seek a temporary restraining order or preliminary injunction or seek another order holding the money post-judgment. And what you are doing, in effect, is converting the lawyer as a guarantor for the other party. Now, in this instance, one of the things that transpired is that in May 1996, well after the money is twice tendered and twice rejected, well after there's an admission that there's no written escrow agreement, that there is no restriction on these funds, the client signs a written authorization to the attorney to release her money to her. It's her obligation to pay her debt. If you put lawyers in the position of having to be responsible for their client's debt payments in the absence of court orders to the contrary, then we are setting up a road where no lawyer, I submit to you, is going to want to hold client funds.
Well, except one of the facts here, as I understand it, that was found, was that the client did not, in fact, on her own initiative, come and make this request, that it was initiated by Mr. Hilson. I've set this up. You come and sign it. And by the way, you owe me money, and here's a way to get it paid. That's a little bit different from suggesting that the client walked into the office and says, that's my money, I demand it, you can't continue to hold it.
I'm not suggesting that there are disputed facts about what transpired. I know what the findings were.
The findings resolve the dispute.
Well, if Your Honor, please, this is a voluntary authorization signed by the client. She could have walked away from that. She had no duty to sign that authorization. She did not have to sign that. If we are now imposing a duty on the respondent not to make a request to get paid or not to make a request that she deal with the debt or not to make a request to her, she can walk away from that. If we're now charging the lawyer as being responsible for the client's actions as well, then we're putting a lawyer in the position of being not only the guarantor for the other party in an instance where their law does not support it, but being a guarantor for his own client's behavior. There has to be some responsibility on the client's part in this instance.
How did the respondent come into possession of this money? Didn't he insist that the client turn the money over to him because it had to be kept in escrow?
No, no, he did not. In fact, he asked the client to deliver the money to her. She had going back a state, she had taken the escrow funds, she had stolen them, using them for her own purpose. He then filed an interpleader action, which, as you know, is subject to fees and expenses and lawyers' fees and costs, and the ultimate division by the Superior Court was different from what the contract determined. And interpleader action was filed, and one of the things you can do is deposit the money with court, which did not happen in this instance. And she garnered up her own money. She scraped it up from whatever circumstances she could, delivered it to the respondent to be put into his client's account.
There's a finding of fact here saying, respondent, your client, sent a letter to Holmes stating it was imperative that she forward to him the entire deposit.
That's correct. That's what he wanted, because he wanted to, because the interpleader action was an action to determine ownership of the funds.
So he got the funds.
He got the funds.
Interpleader actions filed.
That's right.
Judgment is entered.
That's correct.
Okay. Funds are distributed, right? And the check comes back from the
Garganos.
seller, right?
Right.
The Garganos.
Yep.
Saying, no, we're going to appeal. You hold this.
And he says,
I'll hold it in my client's account. I'm not holding it in an
fact,
interest-bearing account.
Let me speak to that letter, because that's Exhibit 20. And that letter says, well, there's a context to that letter that was testified to. It is undisputed, but was not listened to, frankly. The context is the Garganos, the sellers, asked the respondent to hold the money in an interest-bearing account. And what he said was, I'm not going to hold it in an interest-bearing account. I'm going to hold it in my client's account, because it's not your money.
Well, but you know, I was with you up until the point where you got to the interpleader. And typically in the interpleader, you do deposit the money in the court. And here it wasn't done.
Right.
Why doesn't the fact that he filed an interpleader itself create a constructive trust? That he's saying, look, I will represent that I am going to freeze this money until such time as the court directs me. It's like one of those probate actions where you file a petition for instructions. I'm going to hold this money until the court instructs me how to disperse it.
I think the answer is built into the question, with all due respect. I think, in fact, this was an action to determine whose money it was and in what capacity. I don't think that the mere filing of an interpleader converts the lawyer into a guarantor, trustee, or escrow agent for the purpose of those funds.
But if you say this was an action to determine whose money it was, he brought that action, then he knew there was a question of whose money it was.
Isn't it a she? It's a
No, he is
lawyer.
The lawyer, the client is a she, yes.
Okay.
Yes.
He is the lawyer.
Yes, he brought the action to determine
whose
Now,
money it was.
If Your Honor recalls, the
But
board.
so that implies, if not compels, the finding that he didn't know whose money it was.
Indeed, the interpleader action becomes moot if he makes a disbursement of the funds, does it not?
Well, the interpleader action is concluded at that point because there's a judgment, and
Except it was not final because the time for appeal had not yet run.
well, that's a very interesting question. I want to parallel that with an extraordinary finding by the board panel, which the board seems to have adopted, in which they state that there was substantial and understandable confusion as to the nature and ownership of the funds in question. That's the board's conclusion. Now, if the interpleader action gets filed, there is a judgment. It seems to me that it's incumbent upon the courts, if they want to enter an order saying hold the money, or it's incumbent, and I don't mean to criticize Gargano's counsel or them, Mr. Gargano's the lawyer as well, if they want to secure those funds, let them move to do so. Let them take some step that does it, to put the burden back on.
But hasn't the
this
plaintiff
attorney.
in the interpleader action already said, I'm holding them, I need instructions on how to disperse them. Instructions come out, you try to disperse them according to those instructions, but because of a potential pending appeal, the funds are returned. But the interpleader action remains open if an appeal is filed. It seems to me if you've gone ahead and dispersed the funds, particularly if you've dispersed them contrary to the court's instructions, you ought to be notifying the court that the appeal is moot because you no longer hold the funds.
Well, Your Honor, there are two things with respect to that. The judgment says that this is what's to happen with an award to the parties. There is no order sought to secure the funds after that. Part of the money is then dispersed, and the sellers then go into court and file a motion to compel the return of the funds pending the appeal. Part, as you said, if you're supposed to hold the money, they get dispersed to one part of the plaintiffs. The sellers go in and move to compel the return and the court denies that motion? I don't see how in that instance that you now equate the mere filing of an appeal and the lack of an order to the contrary with a specific order that says you're not responsible to do so, which ratifies what the respondent did. That now makes this lawyer a guarantor in these circumstances. I don't see that that's the appropriate step. I don't see that that's the law in the Commonwealth in this instance. I think that's a disturbing trend. And in the circumstances in which this board has concluded what they did, I think this is the wrong result. May I speak very quickly to...
Mr. Boland, you could just help me if you could give me if you have it, the record reference to the motion, the record reference to the motion to which you just referred, the filing which was denied, the post-interpleader judgment motion.
The motion to restore the funds.
To restore the funds?
Restore the funds. You can send me a letter after.
Thank you, because I can't find the
You can
moment.
send me a letter
Let me
after.
speak very quickly to the...
Mr. Boland, your time is up.
May I speak to the false testimony?
No, you've briefed it. It's fine.
Thank you very much. Thank you, Your Honor. This is a difficult case. We very much appreciate it.
Thank you. Ms. Anderson?
May it please the Court, I do not agree with Mr. Boland that this is a difficult case whatsoever. I think this is quite a straightforward case. I think what was going on here was a lot of game playing by Mr. Hilson, and that the argument that is being made now is...
Can I ask you this, though? When the check was returned by the Garganos to the respondent, couldn't he have just turned it over to his client, said, here it is? I mean, couldn't he just... Garganos return the check, say, no, we're appealing. Here, you take the money back.
I'm sorry, I'm not understanding, Your Honor. Could Mr. Hilson have turned it over to his client?
His client, right. Okay, fine. They don't want it, fine. You want to appeal here?
I think it was very clear from Mr. Fraser's letter to Mr. Hilson that he was not asking Ms. Holmes to hold that money. And under no circumstances would he have asked Ms. Holmes to hold the money, because nobody trusted Ms. Holmes.
Well, what's Mr. Hilson's obligation?
Excuse me?
Why did Mr. Hilson have any obligation to do what Mr. Fraser wanted him to do?
Mr. Fraser simply asked Mr. Hilson as another attorney.
Well, I know you can ask another attorney. You're saying...
And he agreed, and Mr. Hilson agreed. I mean, if Mr.
He
Hilson...
didn't agree. He said, I won't hold it in an interest-bearing account.
He said, but I'll hold it in my client funds account. If Mr.
but
Hilson...
Mr. Fraser should know that if it's your client fund and if the client directs you to do something with that, he is beholden to his client. There may be some malpractice on the part of the attorney, I have no idea, but why is that a violation of the disciplinary rule?
Well, the disciplinary rule, Your Honor, says an attorney should not engage in conduct involving dishonesty, fraud, deceit, and
He didn't.
misrepresentation.
He specifically, he announced exactly what his position was.
Right. He said that his position...
He said, I'm not going to do what you want me to do.
Right.
If he had handed client trust money over to another attorney, and the client had objected, with no written statement from the client, bar counsel would be in here saying, on what conceivable basis can you take money out of a client IOTA trust fund and pay some other attorney? She comes running into bar counsel.
Hadn't the client already authorized the payment to the
facts,
Garganos?
yes. The facts, as found by the hearing officer, there are so many facts that there was no question whose money this was at this point. First of all, as you, Judge Sossman and others have pointed out, he filed an interpleader action. He specifically asked the court for permission to deposit the money in the court.
And what did the court do?
The court said, as you pointed out, no, why should we go through all this trouble? I'm going to have this decision made in a month. And that's what Mr. Fraser, the opposing counsel, testified. That's what the judge
So when
said.
the court did that, did the court effectively convert the interpleader into a declaratory judgment action?
I suppose that's a possible interpretation, Your Honor. I can't answer that question. After that, the court issues a judgment.
Was there also a request for declaratory relief?
Yes, there was. Yes, there was. That was part of the case.
So one of the aspects of an interpleader is, here, I'm going to file the money in the court.
Here's the money.
And the
What
court
should I
said,
do with it?
I don't want it.
Right. The court said, you hold it because we can trust you. You're a lawyer. We can trust you for the month until I decide this case. Then the court issues the judgment. Then the judgment comes down. Mr. Hilson has Ms. Holmes into the office, and she signs an authorization saying, send this money to the Garganos. If there was any question before that it was her money, it certainly ended there, where she specifically authorizes him to send it to the Garganos. She relinquishes any right to it that she might have had before then.
No, she doesn't. she can, it's her funds, she can withdraw that. She doesn't relinquish any and all. She says send it, they send it back, and then she says, well, to heck with them, give it back to me.
Well, that never happened, Your Honor, as you
Because then
understand.
he's paying the legal fees. But when you said she relinquished any rights, she didn't
Well,
relinquish
she
any rights.
instructed him to, she authorized him to
And the
turn that money.
Garganos proceeded at their risk. They can accept the money under protest. They can do all kinds of things.
The only disagreement that there ever was evidenced by the correspondence between Mr. Fraser and Mr. Hilson was what kind of an account Mr. Hilson was going to hold the money in. That was the only question. Was he going to bother to set up a
Well,
separate
Mr.
interest?
Fraser may have been putting his client at risk.
He may have, and I don't think sending the money back was a great idea to begin with.
I will
but-
give you an extension of time to file for another month, and then I file a default judgment on the 18th month, and you come screaming in here saying, but I relied on the word of counsel, and let me tell you what the court would do. If you didn't have it in writing, or if you didn't file something in court that said, in fact, by agreement of counsel, the time for extension. I mean, it seemed to me that there were lots of, quote, understandings between counsel, but whether or not that rises to the level of disciplinary action is different.
Disciplinary, but, Your Honor, we're not talking about having to prove that there was an escrow or a trust that was created. All we have to prove here, and what we certainly did prove, is that Mr. Hilson acted in a dishonest fashion. If there had been any doubt in his mind about
Dishonest to whom?
dishonest to Mr. Fraser and to the Garganos and to his client,
What obligation did he have to them? What
he had an
legal
obligation that if he was not going to hold this money for them, that he would at the very least tell them that. If he had ever said to
What is the source
Mr.
of that legal obligation?
the general duty of an attorney, Honor, to act in an honest fashion.
And
He
so if
certainly-
I agree to give you an extension of time for 30 days and you don't file a stipulation, I don't file a stipulation, and then I just go in and get a default judgment, I can file a complaint with the VBO?
You can certainly file it. Whether or not we would determine that there was an action worth disciplining is another matter. But-
Is the judge's endorsement of the motion to return the funds, is that, can that be read as a, essentially, the judge's view that this was not, he was not treating this as an interpleader, but a declaratory judgment action?
I don't entirely.
I mean, the funds to Holmes and the co-broker had been dispersed according to the terms of the judgment.
That's right.
All that was still in dispute was of any kind, was the Garganos' claim that they were entitled to more than half.
Well, no, it
And the
had
judge
been
said, I'm not, basically said, I don't think you've got enough chance of success on appeal. I'm
Right.
not going to make Ms. Holmes and the co-broker.
And the lawyer
the
could
money
have said,
back.
I want an order ordering that those funds be held.
Well, let's go. Let's go. Can we
The judge, can I just put, the judge later said, Judge Delvecchio, I believe it was, on the record, when she discovered a year later that Mr. Hilson had taken these funds, she wrote, Mr. Hilson must immediately return the funds that he said that he agreed to hold in escrow for the Garganos. So, and that appears on the docket in the Plymouth Superior Court action. So if you look at the docket, you can see exactly what Judge Delvecchio's understanding was when she denied the motion in January of 1996. Her understanding was that Mr. Hilson was holding those funds in escrow for the Garganos. There was no question in her mind. There was no question in the mind of the trial judge exactly who Mr. Hilson was holding those funds for.
Is the docket in evidence?
Excuse me?
Is the docket of the Superior Court in evidence?
Yes.
Could we move to January of 1996? As I'm reading the findings of the hearing committee surrounding that, or the hearing, there's a hearing officer, a special hearing officer?
Yes.
Right. They go to the courthouse steps. Mr. Gargano has brought a motion requiring that the respondent regather the money that had been distributed while the appeal was pending. And so the respondent says, here's your check. Here's the $17,787. He said, no, you hold it. The judge denies the motion, requiring that the money be regathered. That's the money that was distributed, the half the money that had already been distributed. Then we have this letter on January 17th, 1996, to the respondent saying, pursuant to our conversation today, please forward the check to me, and that my acceptance isn't going to waive any of my rights. There's no response after that, is there?
No.
And the hearing officer found that the request was received,
Yep.
and that he simply did not respond to it. And this money wasn't actually taken out of the account for months after
And then
that.
there was another letter.
Another letter
In
that Mr.
February,
Fraser
again
sent.
asking for Mr. Hilson to return the funds. Again, he doesn't respond.
No respond again. And then the monies are diverted, or I
Yes,
should say
back in
withdrawn.
May, several
back in
months
May.
later.
Okay.
And the findings of the hearing officer were that during that period, Mr. Hilson became increasingly concerned that Ms. Holmes was not good for the $5,000 or so that she owed him, and that she was hospitalized, she was unemployed, et cetera, and he started to write her some very concerned letters about how he was going to get paid. And then in May, he comes up with this idea of releasing these escrow funds and calling her in there to sign the release. There were so many opportunities here. If there had been any doubt in Mr. Hilson's mind whatsoever about the correct ownership of these funds, he could have gone to court for an order. He could have.
Mr. Anderson, let me ask you this. There's no question that the Garganos can recover from Holmes, is there?
That they can?
Yes.
Well, the Garganos, yes, they could have recovered from Holmes, certainly. Legally, you mean?
Yeah. Practically, maybe no.
Practically, no. Legally, I'm sure they had a good claim against her. The case was settled, so that didn't happen.
What do we make of Judge Del Vecchio's decision, I guess, at the January 17th hearing, that the judgment was final for purposes of the Superior Court proceedings? What does that mean to us?
I don't think that.
What does that mean? What does that mean about the money, the status of the money that Mr. Hilson had in his briefcase at that point in time?
All she was saying, as I understood it, Your Honor, was that she didn't think that Mr. Hilson had violated anything by distributing the money to the brokers on the 27th of September, and of course also by distributing the money to the Garganos. And she certainly didn't get to the issue of whether the money should be in an interest-bearing account or not, because at that point, once Mr. Fraser heard that she was not going to order Mr. Hilson to get the money back, he basically said, all right, well, I might as well get the Garganos' money back, too.
Right, which is
so
what,
that
which
was
is the
why
letter.
when Mr. Hilson offered him the money before the hearing, he said, no, I'm still going to, wait and see what the judge says. After the hearing, he said, okay, I can see, there's no point to this anymore.
Why would Mr. Fraser not have taken the money and said, as he did subsequently, acceptance doesn't waive any of my rights, I take it under protest?
Your Honor, clearly Mr. Fraser could have handled this differently. I don't know that that's a critical issue to this case. I mean, he did not act wisely in retrospect. There's no question about it. He could have held the money himself.
The question for me, Ms. Anderson, is a very simple one. It might be there are all kinds of understandings. There might be all kinds of things of what people believed was going to happen. But the question is, can you point to where the obligation was, where he was instructed not to do it? I mean, one of the things that we ask people to do is to get the orders that they want to get. And you keep saying it's clear that that what was established in the lawsuit was that money was to be paid. It's not at all clear to me that it was that money. It was clear that of the money that the broker had obtained, 50% of that went to the seller. And she was not entitled to rely on all of it.
Right. And then after she came in and she signed the authorization, the checks were written, that money was then earmarked and segregated. I mean, the Driscoll case from 1946 or whatever it is says, it's never an obligation of an attorney to give money belonging to a third party to his client if the client demands it. And the question is the money sufficiently segregated from a pool of money that it can be safely said that that money belongs to a third party? And in this case, it couldn't have been more clear. We're not talking about, an unsegregated pool of funds like a a check from an insurance company to, for a personal injury, where the question is, well, do any of those funds belong to a health insurer?
Was it clear at this point that these were not the funds that had been paid to the broker? In other words, they were not the check that had been put into a separate account. These were, in fact, monies that she had spent those monies, correct?
Yes, yeah, well, it wasn't the same exact cash that had been given to her back in.
No, it's not as if, it is not as if the buyer had given a check on X bank to the broker. The broker had endorsed it over to the lawyer, and the lawyer was holding it.
That's right.
But did anybody know that at the time? Didn't that only come to light later? Much later in the later Gargano's litigation?
Yeah, I do not believe, Your Honor, and I'm not 100% sure that anybody except Mr. Hilson and Ms. Holmes were aware at the time that the...
Had anybody tried or suggested that Hilson was in contempt of court for holding the money and not paying it out when the judgment was rendered?
That it was in contempt of court? I don't believe that was part of the action filed by the Garganos.
Do you think it is feasible on this record that he could have been held in contempt of court?
I think so.
Where's the order? Clear, unequivocal order.
There is no clear, unequivocal order. It would have had to have been, the implication of Judge Del Vecchio, as I said, is Judge Del Vecchio
understand the
believed
implications.
that he had agreed that he was holding it in escrow, but she did not believe she needed to order that because she thought that that was clear from the agreement and the behavior of the parties.
Thank you,
what-
Ms. Anderson.
I'm sorry.